on a piece of paper. If you don't have, I believe I see a writing utensil. I'm not sure if I see a pad of paper. We'll make sure you have that. But given your current demeanor, which is still seems quite animated, and a loud raised voice, I'd ask that you write it down.
I'm going to watch this stream like all by myself, but I keep on deleting everything. Please just shut up.
How's the state doing on its review?
107.
Okay.
Thank you guys for joining. Whoever is watching, thank you. It's a circus show today. Yeah, it's been removed like so many times. So many times. It's not even in the courtroom. It's like in a confined place. Maybe can we call it?
I just want to make a continuing record that Mr. Brooks is still, I can still hear him even though he's muted due to his level, his tone of voice and volume level that he is using from the neighboring courtroom.
For how long it is going to continue? It's been removed, like, I don't know.
So
I can't
all
even
of these
count.
should be included. But they just put them in the numerical order. So hopefully I haven't taken out any numbers. Yeah, there should be numbers.
I can figure it out.
There are numbers.
Okay.
Well,
I was gonna say there's some, like the ones that are in all of ours, I think are numbered.
yeah. But that's just the easiest because this goes after credibility. And then 325. Which, it's before defendant elects not to testify, and we have to toss up that one. But
Yeah.
Mr. Brooks, I'll advise you once again if there are any specific requests for either instructions or categories instructions that you want this court to consider, please write a note to pass to the bailiffs who can let me know. How do I, what page number, what section?
So I think the first concern I have is with regards to the bail jumping. I know that we had charged, there's 2 separate felony cases. The defendant was out on bail. And I do believe it would be assistive to the jury to have the specific case number. So when we first talking about 61 of 107, we start talking about the bail jumping, and then we go specifically on page 63 of 107, and when we could talk about count 74 and 75, I think it might be helpful to put the Milwaukee case number, because they are different case numbers, so that they know exactly what they're finding, that he was out on bail and that as conditions of his release. And those bail bonds were entered into evidence.
Let me look at the information.
And then just, because I think this was just well, I guess I'll have you, when we look at the verdict forms on page 102 to 107 for the bail jumpings, there's verdicts for the bail jumpings for 3 separate counts, 74, 75, 76. I don't think there should not be one for 76. I believe that should be the battery.
That would be true. My computer's just acting up a bit, so I'm gonna search, I'm gonna see what the information says. And then I'll ask Mr. Brooks if he has a position on that. Sometimes it's easier if we just list out, I guess, what the changes are requested. I'm
Sure.
gonna make some notes and then we'll go through
Sure.
them one by one, but so.
And I
first
don't
is
believe it
page-
was spelled out in the amended information.
Say that again?
I don't believe it was spelled out in the amended information.
Right,
So that would be page 63 of 107, whether or not we want to put the specific case numbers.
I can tell you right now, I typically like to follow the information, so I'm probably not inclined to do that, and we can argue that though to the jury, but
Okay.
let's go through the list and then we'll get
Okay.
the defendant's responses if he's
Okay.
would like to give us those, but we'll go through the whole list. So that's the
then-
bail jumping.
Yep, and then with the verdict forms with regard to the bail jumping, just to put on the record, page 102 of 107, I believe there's a count 76, which details it as a bail jumping. I believe that should be the battery.
All right.
I did notice on the motive instruction was incorporated on page 5 of 107. And I know that intent is an element of the battery. I don't believe that was incorporated. I mean, usually it's a standalone instruction. I think the court incorporated it with the first degree intentional homicide because certainly that was,
I think that's part of the pattern instruction.
oh, it is. Okay, then we would ask for motive. I think that there's a 175 instruction that could be given as a standalone.
I'll look at that. Okay, we'll add that.
And then on page 65 of 107, which is the 70, the preliminary instruction, defendant proceeding pro se. There's the standard paragraph, which is the first paragraph listed under this instruction, and then there's an additional paragraph. We are going to object to that additional paragraph. I think it highlights the defendant's bad behavior. So I'd ask that that be taken out.
All right, I made a note of that, keep going.
Okay, with regard to page 106 of 107. I believe that those were add-ons at the end that the court wanted to question the parties about.
Yes.
I believe that there was 325 should be given. One of the witnesses for the state did testify he did have one prior conviction. I believe a witness for the defendant testified that he had a number of convictions. With regard to that same page 106 of 107, instruction 141, where identification of defendant is an issue. I don't know if it is an issue. That wasn't raised during the defendant's closing arguments. His opening arguments. I would know that, or note that the defendant would sometimes cross-examine people on if they were able to see the person driving or the description of the person driving, and he would cross-examine them as to their ability to perceive that. So I guess that would really be up to the defendant if he wishes that to be given. On page 107 of 107, instruction 172, circumstantial evidence, flight, escape, concealment, the state that was included in the initial instruction that we requested, and I would continue to request that instruction be included.
It's really just flight, though.
Correct.
What's that number again?
172.
Yeah, I know, it's just not there. I saw it, it's fine. But only as to flight, I made a correction on it, just gotta find it. Alright.
And I would say concealment to some extent, because he took off some clothes that would have identified him. But again, his running away, his trying to conceal his identity by removing some clothing that was identified by numerous witnesses as him wearing a hoodie or a light colored top.
Those were all, and do you have any requests as it relates to instructions that are not in the packet that should be?
No, Your Honor.
All right, let me turn to Mr. Brooks just to get whether he has his list. I'm not asking for a response yet, Mr. Brooks. What I'm asking you for is whether you have any requests for jury instructions, or if in your review you think anything needs to be changed, deleted, added, etc. I know I'd ask that it be put in writing, but I'll also give you this opportunity to verbally advise the court and make your requests. Do you have any requests as it relates to the jury instructions, sir? I would note he put two boxes right in front of where he's seated, so I can't presently see his face. I see his jacket is off because I can see the outline of his arms, and I can see the jacket on the back of this chair. He is unmuted. I've confirmed previously regarding the audio working, and I will just ask him a second time, sir, do you have any requests as it relates to the draft packet of jury instructions, whether that be any additions, corrections, edits, or deletions?
And Your Honor, would it be possible for the bailiffs to just move the boxes off the table so we can
Yes, I think
see?
that's fair. I'm gonna advise the bailiff to remove the box so I can see Mr. Brooks. I don't know what he's doing behind there. He has quieted down. I haven't heard him in a while. If you could move the second one because it can interfere with the microphone as well. And the third. Mr. Brooks, I'm going to ask you for a third time. Do you have any requests as it relates to the jury instructions? Any requests for instructions that aren't included that you believe should be included? Any edits or deletions from the packet that has been provided to you?
Hey, why do you tell them to move my body?
Because I couldn't see you, sir.
Or what?
I've asked you twice now, and I'll ask you a third time. Do you have any requests as it relates to the jury instructions? Any additions, deletions, edits, or
Hey
otherwise?
man, you don't gotta talk to me like that.
Do you have any requests
First of all,
related
what?
to the jury instructions, sir?
Man, yeah, I got requests. It ain't like they gonna be honored though, cause
As it
nothing
relates
I've
to
been
the
trying
jury
to get
instructions,
done.
sir, what are your?
I heard what the hell you said, man.
Well, Mr. Brooks, that was very disrespectful.
Yeah, and I've been getting disrespected since the beginning of this whole process. So welcome to the club.
Mr. Brooks, do you have any
Has to be
requests?
removed for like the sixth time.
I'm tired of it too.
Do you have any requests as it relates to the jury instructions?
Ain't nobody understand why I'm frustrated. How you gonna sit up there and make decisions based on what you think I said when I didn't give consent for you to do any such thing?
Sir, I understand you may be upset, and I really do,
No, you
but
don't
I've made my
understand nothing.
determinations.
You don't understand nothing. You don't understand anything, Your Honor. You don't. Because
I'm gonna mute him again because he's not answering the questions that I'm very clearly asking him, and I've given him 5 opportunities. Mr. Brooks, do you have any requests as it relates to the jury instructions? I'll unmute you for that answer.
I can't hear everything you're saying.
Mr. Brooks, I know the audio's turned up. I believe you can hear me. You've chosen not to put the headphones on. That's your choice. My final question to you, do you have any requests as it relates to the jury instructions?
I just told you, am I muted? Am I muted?
No.
I just told you, I don't know how many times, I can't hear everything you're saying.
Then you should put the headphones
What about that
on.
don't you understand? What about that don't you understand? If you see headphones, you can see everything, you can see boxes, but then you see headphones.
Have you
No,
asked
no.
for headphones to be provided, sir?
I shouldn't have to ask for them. I didn't ask for my boxes to be moved.
I believe they took them away previously because you were so agitated, they were perhaps afraid you might break
Yeah,
them.
I'm still agitated. I ain't gonna stop being agitated. That ain't gonna stop. You sit up here and do everything you're doing and think God don't see what you're doing? You ought to be ashamed of yourself.
Mr. Brooks, do you have any requests as it relates to the jury
Yeah,
instructions?
I can hear what you're saying. I can hear what you're saying.
You just told me you didn't. So which one is
Yeah,
it?
I got the headphones on. You can't see that?
What are your requests as it relates? What are your requests as it relates to the jury instructions, sir?
Man, don't try to come with this whole little image, sir. Now it's all this, sir, and all this. I'm gonna get where I'm going. Trying to put on this little act like you so worried about what's going on with me. You don't give a damn. Never did.
Mr. Brooks, you're being disrespectful again.
You've been being disrespectful. You've been being disrespectful.
I need to know what your position is regarding the jury instructions. And I need to know it now.
What you mean? Who you talking to?
I'm talking to you. I need to know whether you have any requests as it relates to the jury instructions, sir.
Yeah, first of all, why am I charged with 2 bail jumpings when I was already charged in Milwaukee for the same bail jumping? That's double jeopardy.
That's not double jeopardy. Your objection is
It is
noted.
double
It's
jeopardy.
overruled.
It is double jeopardy. How you gonna charge me with the same charge that I'm already charged with? You can't do that. The Fifth Amendment says that you can't place somebody in jeopardy of life and limb twice. I'm already charged with the same count in Milwaukee. For the same case. It's the same bail jumping charge. So how am I charged with that here?
Sir, I'm not gonna provide a legal explanation other than to say I've reviewed that. Your objection is noted, but the jury will be instructed regarding the bail jumping.
It can't be because that's double jeopardy. Under the law, if two charges are identical in nature, you cannot place me in jeopardy of life and limb twice. You can't do that. The
What's
same
your next?
case- The same case number.
What's your next request, sir? I'm noting your objection.
I'm trying to talk. Can I get it out? You always want me to not interrupt you, but you always find a way to talk over me.
I understand your position. I'm saying it's
You
overruled.
always want respect. You always want respect, but don't want to get it. I'm charged with the same bail jumping charge here that I've already been charged with. That is double jeopardy. You can't charge me for the same exact bail jumping that I'm already charged with, that I was charged with before this even came about.
Sir, the bail jumping charges in Waukesha County are based upon your violating your bail while in Waukesha County by driving through the Christmas parade and allegedly killing 6 people and injuring 61 others.
Okay.
That's the distinction.
Again, there is no distinction. It's the same charge.
It's the same offense. It doesn't mean it's the same factual basis, sir.
He is not
It
charged
is.
with bail jumping with the data violation of November 21 in Milwaukee County anywhere. Further, the double jeopardy prohibition would prevent him from being convicted twice, not charged twice.
All right, so we've addressed that, sir. What other requests do you have as it relates to the jury instructions?
I want to know why I'm even charged twice with the same thing. You can't charge me in pursuant to a case in Milwaukee that I'm already charged with bail jumping for. I'm already charged with bail jumping for that already. So you can't essentially say, oh, well, because you were already on bail, we're gonna charge you.
It's a different date of violation, sir. The conduct for the bail jumping is related to the allegation that you committed a new crime in Waukesha County while out on bond from the Milwaukee County case.
Yeah, but I'm referring to the first bail jumping count, the first one. I'm not referring to both of them, I'm referring to one of them.
My understanding, sir, is there's different dates of violations as it relates to that. So I've noted your objection now repeatedly. I understand it. Your request to, I guess, dismiss the bail jumping counts are denied.
I didn't say nothing about counts, I said one.
Whether it's one count or both, it's denied.
Am I not being understood? You can't charge me with the same charge twice, you can't.
It's two separate cases, sir. There's two.
Isn't that 971.23? Isn't that the statute? That refers to the double.
All right, sir,
jeopardy
I'm not
clause,
gonna have
that
an
refers to the
argument.
85?
This isn't fruitful. I understand what you're saying. You're saying there shouldn't be 2 counts of bail jumping. You believe it's double
It should be,
jeopardy.
because
I
I'm
disagree
already
with
charged
that.
with it.
There's
I'm
separate.
already charged with it though.
This is a circular argument, sir. It doesn't change the fact that, from my perspective, the 2 bail jumping counts are going to proceed forward. There's been sufficient evidence presented to warrant the jury being instructed.
They can't.
What other requests do you have, sir?
So today the judge has been so smart, because since this,
Just like
whatever,
Mr.
that was
Brooks,
started.
what other
He's
requests
been
do
so
you
good
have?
and so disruptive. So the judge decided he has to be confined in that room. So he is so pissed. It's been like 5 times being removed from the courtroom. So now he's confined and we can't even hear the sound. I can't even hear him, so sorry. Just wanted to make it.
I'll let you do what you was doing. No matter how egregious and biased it is, I'll let you do what you was doing. Because we both know that what you're doing is not right.
Mr. Brooks, I'm going to refocus your attention to the jury instructions. All of your objections are noted. I understand that. If you can't answer my question, I'm going to move on.
You can't. I haven't given you consent. Just like
All right, I'm going to mute him once again. He refuses to answer simple questions regarding if he has any requests. He just made an argument regarding the bail jumping, so clearly he has an understanding about the law as it relates to that. It may be a misunderstanding about the law and double jeopardy, but he made an argument. I've denied it. I'd like to know if he has any other requests. If he can stay on topic, I'll I will unmute him again, and he can tell me the list, just like the state went through a list. I need to get through their list. I'm asking you to list out all your requests, and then I will take each one up in turn. So here is your opportunity to give me your other requests, not debate with me about prior rulings. Go ahead, Mr. Brooks.
Don't sit up here and try to play no game talking about you giving somebody an opportunity that you haven't gave me an opportunity to properly defend myself and put evidence, put stuff into evidence, which I've asked you repeatedly to do before we even got to the trial. You told me we wasn't in the evidentiary phase.
Mr. Brooks, do you have any other requests as it relates to the jury instructions? This is probably the 10th or so time I've asked you this question.
No, it's not. No, it's not. So please stop being incorrect, Your Honor. Please stop.
Do you have any additional requests as it relates to the jury instructions?
Yeah.
Oh.
That first count 74 bail jumping needs to be dismissed. You can't charge me with 2 things. You can't charge me with the same charge twice.
All right, I've made a note of that. What's the next issue?
Either one county gonna charge me with it or y'all, but it can't be both. It's the same, it's pursuant to the same exact thing that I was on bail for. The same exact thing, the same exact case. So why are we giving the jury instructions on 2 cases from another county?
I've made a note of that. What other requests do you have?
Man, this is ridiculous. So I'm not even able to adequately defend myself, present evidence, do anything, because everything I say is gonna be found a reason for it not to be valid. What are we doing here, Your Honor? What is the
Mr. Brooks.
Why should I be here when
I've made a note of your request as to count 74. Do you have any other requests as it relates to the jury instructions?
Why are we even having jury instructions? Why do I have to even sit here in this courtroom at this point? Because everything you've been doing without my consent anyway, so you're gonna find a way to do this without my consent. So why do I need to be here for?
Your objection for lack of consent is noted for the record.
Okay, yeah.
Any other requests, sir?
You talk a good game. You talk a good game to save yourself enough face. But everything I put up, it has no merit in your court. None.
All right, I've asked him many times. I've advised him, and I'll advise him once again. If he fails to answer the question, I'm moving on. Do you have any other requests as it relates to the jury instructions, sir?
You can't move on because I haven't given you consent to.
All right, he did not answer. So I'm muting him again. The only request that he has made as it relates to the jury instructions, as he pounded his fist once again, raised his voice. I understand, I really do, that he's upset with my decision to cut off his ability to present a defense, but that decision was made based on his conduct and his conduct alone, as I've outlined already on the record. So the only request that he made was as it relates to the bail jumping counts. I'm denying those requests, whether it be to dismiss one count or to dismiss both on double jeopardy, or to just not instruct the jury. However way I interpret it, I'm denying that. All right, let me go through the state's.
Your Honor, can I add one more?
Sure.
I'm sorry, 154 summary of evidence. I believe we had a map, actually two maps that summarize the, we had three maps. I think the one was summarized his route, the path that he took. The other one summarized the victims who were struck in the specific locations. And the other one summarized the positions of the law enforcement officers at the various intersections and throughout the parade route.
I'll make a note of that. I don't believe I saw the jury view instruction either. I mean, that was given to them at the time. I don't know that it needs to be reread, but I think we need to consider that as well. And that was my version of 152. All right, so let me go through the list from the state. Turning to page 61. So I've considered the request by the state. I am going to rely on what information they put in the charging document. I'm going to deny the request to include the specific case numbers. There's evidence, of course, that was received regarding the two separate cases out of Milwaukee County that form the basis for both of the bail jumping counts. It will be up to the jury to review the evidence and make a determination. As to the verdict forms, though, that were referenced previously, at least the description of them in the jury instructions, that obviously the third count of
I
bail
just
jumping
want to
is
say
incorrect.
thank
It
you
needs to be
guys for
battery, and that
watching.
change will be
Like,
made.
at least
I'm
I'm
also
not by
having Madam
myself, so
Clerk
thank you guys.
include
Thank you so
all the
much. Just
numbers
give
for
a
the
thumbs
jury
up.
instructions when they go back, so it's very clear. Some of them did not have them on, just frankly from prior cases that she and I have worked on, but in this case, I want to be very clear with all of the numbers. So I think I've addressed the first two bullet points. As far as the motive instruction as a standalone, I believe that is appropriate, and I'll instruct Madam Clerk to include that. As far as where it goes, I'm gonna just, any instructions that we add should just be in the numerical order, unless there's a other request that's made. Then the state also made a request as it relates to jury instruction 70, which is found on page 65. So as it relates to this, the state is asking that I simply instruct the jury based on the pattern instruction and not include that second paragraph. I had previously advised the jury with another paragraph that I was contemplating including, even if I took out that big paragraph that just said, "At times, Mr. Brooks has appeared from another courtroom. This must not influence your verdict in any manner." What's the state's position on including that, but taking out the paragraph you request to be taken out?
It's fine.
Mr. Brooks, do you have any position on that? Which is, so jury instruction 70 has to do with the defendant proceeding pro se. The pattern instruction would be basically the first paragraph. I need the bailiffs to move the boxes away from his face. I need to be able to see him. He can keep them on the table, but they need to be moved off to the side, and if he does it one more time, then I will instruct the bailiffs to take the boxes away. Those are trial prep materials. If there's something in those materials related to jury instructions, he should take those out now. Otherwise, they need to be moved away from the microphones and away from blocking his face.
I'm not putting them there, I'm just saying, I'm putting them there for a reason, and nothing to do with her being
Mr. Brooks, do you have any position on the verbiage of jury instruction
Don't ask me-
70
don't
on
ask me
page
no question.
65?
Don't ask me no question. Are you my accuser? Are you my accuser, Your Honor?
All right, he's choosing not to answer, so I'll mute him again. It's unfortunate that he's deciding not to participate in this. I agree with the state. I don't need to highlight with that second paragraph. I will take that out, but I will include in the paragraph that reads, at times, comma, Mr. Brooks has appeared from another courtroom, period. This must not influence your verdict in any manner. Inclusion of the instructions that were put on the last couple of pages include 325 impeachment of witness. Its prior conviction, the part about juvenile adjudication, should be struck from the heading. And it should read, evidence has been received that one or more witness in this trial has been convicted of a crime. There were 2 witnesses that was applicable to. The remainder will be as is. And that was 1 witness for the state, 1 witness for the defense. I just will add that if Mr. Brooks has any position about these requests, he should, he is currently muted. He can raise his hand and I'll unmute. Otherwise, he can pass a note to the bailiff or simply tell the bailiff, who can then tell me and I can unmute him. But unless he tells me that, I'm going to assume he's made a decision not to provide further comment based upon the last statement he made to me. Then 141, I believe that's appropriate given the evidence that has been received. That's on identification of defendant is an issue. That I will instruct the jury accordingly unless there's a request from Mr. Brooks to take that out. Is there a request from you, sir, to take 141 out? I'll unmute for that purpose. It's found on page 106 because it's at the end of the instructions. This is the instruction on identification of the defendant and where it's at issue in a case. I believe it's appropriate given the testimony in this case. Do you have any position on that, sir? You are unmuted, so you can simply answer yes or no. No response. Then 172, circumstantial evidence, flight, concealment, I believe is appropriate given the evidence that has been received during this case. Yes, sir?
Am I unmuted?
You have been.
Am I unmuted?
You are.
So how long before you mute? As soon as I say something?
Depends on what you say, how you say it, and if it's responsive to what we're doing.
Why do I have to be responsive to what you guys are doing? Nothing I say even matters at this point, so what's the point of me being responsive? You can't make decisions for me.
Mr. Brooks, I'm gonna mute you unless you can participate in what we're doing, which is discussing the jury instructions.
I'm gonna tell the jury the truth. That's what I'm gonna do. I'm gonna tell them what hasn't been told to me. I haven't been able to.
Mr. Brooks, I'm gonna mute you because we're trying to discuss the jury instructions, not what you're going to say during your closing argument. I will get to that later. In terms of instruction 172, I'll instruct Madam Clerk to take out of the heading the word escape. Should just say flight concealment. And then I've reviewed 154. I believe that's appropriate. I'm going to pull it up just as a draft. I'm not sure if there's anything that needs to be. So the pattern instruction talks about a chart. Is there any request from the state as to just keep that or modify that in any way based upon the evidence that was presented?
Just pull it up right now.
Because you actually submitted maps and things were received. I don't know that summary.
I think that there was a summary of the
believe that was exhibit 141.
But that was received, wasn't it?
And there were some charts of the extreme dance team, the formation, and dancing
Right.
grannies.
Do you have the exhibit list, Madam Clerk? What are those numbers again? I wrote 141.
We're just looking for the extreme dance and dancing granny charts.
Grannies is 54.
54 would be the dancing grannies,
Okay,
And 33 is extreme.
and 33 is the extreme dance team.
so 54, 141, and 33.
Yes.
Do you think the use of the word chart is correct, or should that be,
I would say diagram and maps. The court has allowed the use of diagrams and maps to organize the evidence.
the maps were evidence though? What this instruction says is the court has allowed the use of a chart to organize the evidence and to assist you in understanding it. The chart itself is not evidence. It is a summary of some of the evidence that was permitted or presented. However, it is the evidence that controls. You should rely on the chart only to the extent that you believe it accurately and properly summarizes the evidence.
Then we think 154 should not be given
That's what I was wondering.
because
So
they were all admitted.
they were all admitted based upon how they were presented and the
I apologize.
testimony regarding them. Typically, where that comes in is for use in openings and closings solely that are based upon evidence, and we anticipate those things coming in, not when there's been an actual document that's been admitted. So I don't think 154 is needed, and I'll deny that request. What about 152 regarding the view?
As I read that, that was given prior to the view, and I think that was appropriately given at that time. I don't believe it goes into the closing or the final instructions. would
That
be
was
my position.
my inclination, but I wanted to get the party's position on that. I'll once again unmute Mr. Brooks and just ask him if he has any position regarding any of these last issues that we've discussed with, as it relates to the jury instructions. Anything from you, sir, on the jury instructions? He's not responding to the question. I believe that covers all of the issues that were raised by the parties then.
Am I unmuted?
You are. I'll give you one final opportunity to tell me if you have any requests as it relates to the jury instructions, sir.
What you mean you giving me one final thing? I didn't consent to nothing that y'all been talking about. And I say y'all because I haven't been participating in none of that.
I understand, sir, your objection's noted. Your lack of consent is noted.
Okay, I don't see what's going on in there. So how's decisions being made without me being able to consent to it?
Sir, you forfeited your right to be present in this courtroom by your conduct, and you have not
No,
requested to come back.
Actually, you took a break, so let's make sure the record is correct. You took a 10-minute break,
I did.
at which time I was brought back into this courtroom.
I was advised you wanted to stay, sir.
Okay, and you've been forcing me to come over here from the get-go. Why couldn't you force me to come back over here where I'm supposed to be at?
Sir, my understanding is you requested to stay in the other courtroom. I thought I put that on the record at the beginning. If I did not, I'll make that part of the record now. I was advised by the bailiffs that you were requesting to stay in that courtroom. I certainly advised you prior to that if there was a time you wanted to come back in, all you needed to do was ask. You've done that previously.
Yeah, but
And even even during this time, though, you've been incredibly disruptive
I can't say that.
during, I mean, at one point you were muted for an extended period of time and you were yelling so loud, sir. We could hear you in this courtroom. I couldn't decipher what you were saying. And I was also made aware that another branch could hear you. So you continued your
that's
disruptive
fine.
behavior.
That's fine, because at the end of the day, I should be heard. I have the First Amendment right to be heard. So if I'm gonna be constantly muted, the only way for me to be heard is for me to raise my voice.
Mr. Brooks, one final time, do you have any requests as it relates to the jury instructions? Otherwise, I'm going to approve them, and I'm gonna take a break, and then we'll come back in the afternoon to go over verdict forms.
I didn't answer yes or no, so how do you consent to anything without me answering the question?
Are you going to answer the question, sir?
You can't force me to do it. You can't just say, I'm gonna do this because.
Sir, but you also can't stall the proceedings by failing to answer.
I didn't try to start the proceedings. You the one that held me in contempt.
I never held you in contempt. All right, I'm gonna mute him once again because he refuses to answer a very simple question about whether he has any requests as it relates to the jury instructions. I will work on making all the changes with Madam Clerk, finalizing the order, print them off again. She has been working on the verdict forms, which are of course separate, which need to be approved by this court. So those will be printed off. A set will be provided to the state. A set will be provided to Mr. Brooks. We'll take I'll do a 90-minute lunch break, so it's 11:27. So we'll come back at 1 o'clock to finalize the verdicts and the jury instructions.
And Your Honor, with regard to sequestration of the jurors and the alternates and those issues, did you want to address those this afternoon?
Yes,
Okay,
we can do that.
thank you.
I can put on the record that I had the civilian jury bailiffs provide the parties. We have a letter regarding sequestration. There's an emergency contact form, so all of the jurors were made aware of that. They know that. Of course, once the case is, all of the instructions are read and the parties make their arguments, and then there's some final instructions at the end, and the case goes to the jury. Obviously, only 12 of the 15 will be deliberating, but we can make a more full record of that this afternoon.
Thank you.
All right, we are in recess until 1 o'clock. I'm just instructing the parties to stay until the handout of the verdicts, and then you can leave for lunch. Thank you.
But isn't recession and something to should I just say something? Say what?
To the border before the midterms, and those numbers are.
First, Bill Malugin live at the border in Eagle Pass, Texas. And Bill, it was pretty interesting that at 11 p.m. on a Friday night, the press office at Department of Homeland Security decides to release some numbers. 11 p.m. on a Friday night, let's just say that's an unusual time to be releasing a statement.
Dana, good morning to you. That's exactly right. I'd say it's about as blatant of a Friday night news drop as you are ever going to see. And keep in mind, these September numbers are the last numbers the public would get a chance to see when it comes to the border before the midterms. And those numbers are historic. Let's take a look at them right now. September 2022, fiscal year 2022, CBP reporting more than 227,000 migrant encounters. That is the highest September in DHS history. The numbers also show fiscal fiscal year
pass through the
2022
border,
ended
like,
with nearly
I don't need-
2.4 million migrant encounters. That is the highest fiscal
my
year
God.
ever recorded. And then perhaps most concerning, if we can pull this graphic up, fiscal year 2022 ended with 98 Border Patrol arrests of people on the FBI's terror watch list. Just to put that number in perspective for you, under President Trump, the highest number of terror watch list arrests was 6 in 2018. President Biden just had 98 in fiscal year 2022. And the numbers are not slowing down. Take a look at this video we shot early this morning here on the north side of
That's
Eagle
why I
Pass, showing
clicked
yet
the
another
video.
massive group crossing illegally. Well over 100 people in total in a 24-hour span over the weekend. We had more than 1,500 illegal crossings, and CBP sources tell Fox News here in this Del Rio sector, in just the first 3 weeks of October, we have already had more than 29,000 illegal crossings. That represents a 50% increase over the same time last year. Then, take a look at this wild video provided to us by a source out of the Rio Grande Valley, showing a group of shirtless drug smugglers who have just come across the border. They just swam across the river. They are carrying bundles of narcotics in broad daylight. They run up to a waiting vehicle in a parking lot, and they load that vehicle up with the drugs before they run off back to Mexico, and the driver takes off. Well, Texas DPS tells us they ended up getting into a pursuit with that driver, and they arrested him. If we can pull up these photos right here, that suspect, the driver behind that wheel, was an 18-year-old U.S. citizen who you can see is smirking at the camera after they arrested him. He had 10 bundles of drugs in that vehicle with him. He was arrested and charged, but just goes to show there was no CBP, no Border Patrol to stop those guys from bringing those drugs in. It was Texas DPS who ended up catching that drug smuggler. And back out here live, another record at the border. Fiscal year 2022, CBP sources tell Fox News there were 856 migrant deaths. That is the highest number ever recorded. And Dana, the startling thing about that almost 2.4 million number, that does not include the 600,000 gotaways who crossed our border successfully evading apprehension last year. We'll send it back to you.
Bill, any other media down there covering this?
No?
You know what? It's pretty wild. We actually had print media from Japan out here this morning, and then we just had a Dutch TV crew come up to us and ask us where the spots are to find migrant crossings. So yes, there's press down here. They're just not from the United States.
Not American. Thank you so much, Bill.
I'm Steve Doocy.
I'm Brian Kilmeade.
And I'm Ainsley Earhart. And click here to subscribe to the Fox News YouTube page to catch our hottest interviews and most compelling analysis.
An 18-year-old is a drug dealer. How is that possible with so many drugs? Let me just see. How is it possible?
You can see is smirking at the camera after they arrested him. He had 10 bundles of drugs in that vehicle with him. He was arrested and charged, but just goes to show there was no CBP, no Border Patrol to stop those guys from bringing those drugs in. It was Texas DPS who ended up catching that drug.
How? Look at him. He's like smiling. How did he smuggle those drugs? Nah. They're pinning this on him. I can't believe that he's a drug dealer. I don't think so.
Smuggler. And back out here live, another record at the border. Fiscal year 2022, CBP sources tell Fox News there were 856 migrant deaths. That is the highest number ever recorded. And Dana, the startling thing about that almost 2.4 million number, that does not include the 600,000 gotaways who crossed our border successfully evading apprehension last year. We'll send it back to you.
Bill, any other media down there covering this?
You know what? It's pretty wild. We actually had print media from Japan out here this morning, and then we just had a Dutch TV crew come up to us and ask us where the spots are to find migrant crossings. So yes, there's press down here. They're just not from the United States.
Not American. Thank you so much, Bill.
I'm Steve Doocy.
I'm Brian Kilmeade.
And I'm Ainsley Earhart. And click here to subscribe to the Fox News YouTube page to catch.
So we're gonna go back to, how is it? Anyway, Let me look for something to share. Their hearing is so boring today. I don't know how to do live. This is frustrating, but anyway, I'm just trying. I'm trying. If I don't do it, then I will not get better at it. So I'd rather just do it, try my best. Yeah, for the next time. I miss. So very nice. I don't know. Maybe I might get a strike, but I just want to see. Yeah, this is interesting. Um,
Recognize that video?
so I think this is a video of him being arrested. So let's watch.
Play the first 5 or 10 seconds of that just to see if you recognize it, okay? All right, we've played 6 seconds. Do you recognize that video?
I do.
What is it?
It is my body camera video of walking down Elizabeth Street.
From November 21st?
Yes, sir.
leading.
I will overrule it, and the answer may stand.
Does this video and the associated audio accurately reflect what happened that night as you saw it?
Objection leading.
Overruled.
Yes, sir.
I'd move Exhibit 80 into evidence and ask to publish.
Objection. Well, let me see.
Overruled. Exhibit 80 is received. Permission to publish is granted. For the record, please tell me the total length.
It is a 5-minute video.
Thank you. Go ahead.
We will start at the beginning. We're going to play it with audio, and we will pause at certain points, and I'll point out the timestamps when we pause. So we'll start from the beginning, please.
Big Ben.
Any unit that is on Elizabeth Street currently advised.
Robert 277.
Robert 277.
Put your hands up! Hands up! Hands up! Get on the ground! Get on the ground! Do it now! Hey! Taking one of the hospitals for a plan here. What did I do? Lay on your stomach. What did I do? Robert 277, are you on Elizabeth?
We've paused at 53 seconds. A few moments earlier in the video, we saw what appeared to be a handgun. Does that sound right to you?
Yes, sir.
Who was the person holding that handgun?
That was me.
And who were, well, let's see, let me strike that. I want to direct your attention to the top right corner of the screen here. There appears to be some type of timestamp. Do you see that?
Objection leading.
Overruled. I do, yes.
Do you know if that is an accurate military timestamp?
Objection leading.
Overruled. You may answer.
That does not accurately reflect the time it occurred, no.
So it was not 11:11 p.m. at the time this video was recording?
Objection leading.
Oh, sustained as to the form of the question.
Do you know approximately what time it was that this video was recorded?
I know that I initially began to respond to the scene at about 20 minutes to 5. And I would be guessing about how much time elapsed, but I would say it wasn't more than a half hour or 40 minutes to this point.
Okay. The person who is depicted in the video at this point, at 53 seconds, that's what... Describe where in the video you first saw that person.
Objection leading.
Overruled. You may answer.
I first saw him standing on the porch.
And what, if anything, did you see that person doing when you first saw him?
Objection leading.
Overruled. You may answer.
He appeared to be rather agitated.
Why do you say that?
Objection leading.
Overruled. It's not leading. You may answer.
He was moving back and forth on the porch and gesturing.
Do you recall what you were wearing that evening?
I do.
What?
The exact same set of clothing that I'm wearing today.
Including long sleeves?
Yes.
Objection leading.
Overruled.
Did this person, depicted at 53 seconds, draw your attention in any way based on what he was wearing?
Yes.
Why?
It was chilly out, lower 40s, upper 30s, and he was in a t-shirt, jogging pants, and no shoes.
We can resume playing here at 53 seconds, please.
It's doing all right. You got something with your name on it, man? No. Okay, lads. Cooperate with us. Okay.
We paused at 1 minute and 4 seconds. What did we see in that portion of the video?
That was a sandwich.
Where did that sandwich come from?
Objection leading.
Overruled.
His right pants pocket.
The subject on the ground is?
Yes, sir.
Okay. Please resume at 1:04.
Robert 277.
We paused at 1 minute and 14 seconds. Did you at some point ask the subject depicted in the video at 1:14 to identify himself by name?
Go ahead.
I did.
What was that person's response?
He identified himself as Daryl Brooks.
Do you see Mr. Brooks in the courtroom today?
I do.
Can you point him out for us by telling us where he's sitting and what he's wearing?
He is seated at the defense table wearing a dark-colored suit and striped tie and a mask over his face.
Just to be thorough, Your Honor, could we please have Mr. Brooks remove his mask momentarily?
Thank you, Mr. Brooks. Go ahead.
Now that Mr. Brooks has removed his mask, does that change anything about your testimony today?
Objection. I don't consent to being called that name. It's
You're-
leading.
You may go ahead and answer.
That's Daryl Brooks.
Could we please play from 114?
There's multiple units. Name is 216, you have to attend. What is your name? Brooks. First name? Durrell. I'm waiting for a minute.
Paused at 1 minute and 23 seconds. Sitting on the witness stand today, do you acknowledge that Mr. Brooks has a short haircut?
Objection. I don't consent to being called that name. He's leading.
Sustained as to the form of the question, please.
How would you describe Mr. Brooks's haircut today?
Objection. I don't consent to being called that name.
Sir, I understand your objection. Please do not interrupt with that further so that the questioning of the witnesses may continue. You may answer.
If you say that name, I'm objecting.
And the jury will disregard the objection if it's solely for the name purposes. Go ahead.
Mr. Brooks has his hair cut close today.
What about when he took his face mask down? Did you notice his facial hair?
Objection. Leading.
Overruled.
He does have facial hair.
Did you notice anything different about his facial hair today versus in the video?
Objection. Leading.
Overruled. The witness may answer.
That is also trimmed closer.
Does the hairstyle and the facial hairstyle here in court today give you any pause or concern over whether or not it's Mr. Brooks in the video?
Objection.
Go ahead and answer, please.
No, not at all.
Let's resume playing at 123.
With the objection noted for the record.
I just used somebody's phone to call for a minute, that's all. Oh, okay. That's what I need, yeah. One male, 1026, the black male, red short sleeve shirt.
I'll tell you what. If everything turns out to be on the up and up, life will be good, and you'll be on your way, all right?
I got it. Suspect, I presume?
Unknown. Ask him. Ask him if he knows. He was on the porch here.
Yeah, I was using his phone. What's your location? I was using his phone. You're holding the WMH road, loading her down. I called my... Any squads available for a transport? Just give me a lift. That's all. I was just using his phone.
Sarah, this is Schwartz. I'm leaving WSC. Where do you need me?
Can I just sit up? I was freezing. Can I please just sit up? You have any weapons on you? No, sir. What's your name, guy? 9209. I just told her my name. What is your name? Yes, sir. What's your first name? Darrell Brooks? Yes, sir.
Additional victims to return on the next block.
Copy. No additional victims.
This matches the description of the guy that got called on who was going door to door over here.
Yeah, I was trying.
Where are your shoes, man?
I was trying to use somebody's phone.
Where are your shoes?
My flip-flops is in his house.
Paused at 2 minutes and 49 seconds. Did you hear the last thing said by the suspect on the ground at this point?
Objection.
Yes.
Leading.
Overruled.
What did he say?
Objection. Leading.
Overruled. You may answer.
He said, my flip-flops is in his house.
Do you know if any flip-flops or any other shoes of any kind were ever retrieved from the residence that this was taking place in front of?
Objection. Speculative.
Overruled. You may answer.
I did go in the house and speak to the resident there and asked if he had left shoes or outer garments or anything like that, and he said that he had not.
You've now repeated yourself a number of times, so I'm going to turn to the state to see if they have any response.
I'm going to stop this stream because I can't. This has been too long. And for those who watched with me, thank you guys so much. I'm ending the stream, so sorry. Thank you guys. Next time I try not to stream things that are being live streamed from court maybe. So thank you guys for watching. Bye, ciao. I think I need to stick.